Obviously the principle is that the public ought to be able to see justice being done in their own courts, and if the public and journalists are excluded from courts, it's very difficult for people to have confidence that the decisions of the courts are fair and reasonable and based on the evidence. And so the proposal that we should introduce closed procedures into sensitive court cases really attacks a very fundamental principle that we've adhered to for, I suppose, centuries. It's always been a very, very strong principle of British justice that justice is open and transparent, so that the public can make their own judgments about cases and their own judgments about whether judges' judgments are right or wrong. And often, of course, the public disagree with the judgment of judges, and that's fine. That's part of the process, and it's part of educating the judiciary as much as it's part of educating the public. So I think any process which closes off justice from the public is necessarily a bad thing. One of the problems about the process which the government is now apparently pushing is that in the future it may be more difficult for us to find out when the security agencies have misbehaved, when they've been involved perhaps from time to time in unlawful activity. And I think that's an attack on the rule of law. I think it's a bad thing. I think it's bad not just for us, I think it's bad for the agencies themselves. They need that sort of pressure, as we all do, to keep ourselves on the straight and narrow. That's what the law is about. It's about offering public sanctions when people break it. And if the security services suddenly wake up one morning to discover the government have offered them an escape route from that, that's not a good development. It's a bad thing for them as well as for us.